So good afternoon to all of you. It's a pleasure to be here on this panel regarding advertising law all over the globe. Obviously, we cannot cover all the globe, but we have people from Chile, which Ariela is going to be here, Jeff from the United States, Kelly from Canada, and Roberta from Brazil. Entering into our second year of pandemic, I think we have to know what's happening in each of the jurisdictions, and I thank all of you to be here. I'm going to present you the speakers. First of all, we have Roberta Medina from Veirano Advogados in Brazil. Then Ariela Agosin from Albagli Zaliasnik in Chile. Kelly Harris from Miller Thomson in Canada. And obviously our president, Jeff Greenbaum from Frankfurt, Kurnit in the United States. Thank you very much to all of you for being here. And it's a pleasure to have you in this webinar that I think all of us will know a little bit of what's happening in each of your countries. And we'll start with Roberta, ladies first. And please, Roberta, welcome.
Hello, can you all hear me?
Yes, we can.
Hello, everyone. My name is Roberta. I am an attorney here in Veirano Advogados, an office in Brazil. So today I'm going to be talking to you about 3 hot topics in Brazil. The first one being diversity and inclusion in advertising. The second one, digital influencers and advertising for children. So let's go ahead to the first one. I just want to introduce a few numbers very quick. In 2015, the percentage of Black female protagonists in television commercials here in Brazil was only 4%, rising to 22% by 2020. And even with these numbers, today, white women are still the majority, occupying 70% of the main roles. In the male sphere, we have, since 2015, only 1% of Black men occupying main roles in commercials. But by 2020, this number increased to 15%. So here we have a fact. The fact is that Brazilian companies, and we see that every day, they are betting on diversity as the focus of their campaigns. And we want to understand why. But to be honest with you, the reason is really straightforward, it's really obvious. The shares of these companies are increasing exponentially. So just to give you guys an example on Natura, which is a cosmetic brand here in Brazil, promoted a Father's Day campaign. And this campaign was starring Tami de Miranda, who is a famous trans man and also father. And after this campaign aired, the shares of Natura increased by 10%. So this was a huge improvement, and it's something that we need to consider. Nowadays, something that is really interesting is happening in Brazil, which is that the company's big bets are on celebrities that are part of reality shows and part of the LGBT community. So I'll explain that to you. We have the culture of reality shows. Things like Big Brother, Brazilians just love reality shows. And we like people with big prominence to the LGBT cause. So what companies do is that they look for these participants after the show ends, and then they offer a role in commercials to promote their brands, and it is always a hit. So I would say since 2020, this is something that is becoming more and more common. And I'm going to show you a few examples in here. This one is a campaign from General Motors. And this campaign was really nice. It was a hit here in Brazil because this commercial took an extremely sexist phrase and created an innovative campaign that promotes empowerment to women. So just a quick background, for many years here in Brazil, the role of the Brazilian woman was just limited to being a housewife. And imagine someone that could only drive a stove in the kitchen, if you know what I'm saying. And here it's still common, to be honest, to hear that women are bad drivers. So what General Motors did was sensational. They took that speech and they prepared a commercial to promote their Chevrolet Tracker car. And unfortunately, I cannot play the commercial to you, but I'm gonna send after this presentation with subtitles in English. But basically, in this commercial, we see a man, and this man is screaming at a woman who was driving, and he says something like, "Go home and drive a stove." And then this commercial shows a lot of women, successful women, and we have a pilot, a scientist, we have a surfer, and they are all driving Chevrolet car, but they are also looking at the camera and being very ironic. They are saying, "Drive a stove." And it's kind of funny. It's really nice. And finally, we have Paola Carosella, who is a famous cook, and she's actually driving a stove because she's in the kitchen. She's performing as a cook. And then she looks at the camera and she says, "We are women, we can drive whatever we want." So this campaign was huge. It was a huge success. And we also have a few other examples. So here we see, we have Doritos. Let me see if I can find, no, it is this first one. We have this Doritos campaign, and they launched this package which had the rainbow flag. And also we had this commercial starring this person that is a member of the LGBT community, is a singer, and is very famous as well. So we also had the second example, which is from Natura, as I said before. We have this one from Avon, and also this one from Samsung with Black people. And we have these two campaigns which are really nice. One is from Burger King, and the other one is from Volkswagen, and they have as a target disabled people. So it is very inclusive, and it was also a huge success. So moving on to my second topic, I want to talk about the digital influencer guide that was developed by CONAR, which is the Brazilian Council for Advertising and Self-Regulation here in Brazil. And this guide contains basically instructions to commercial content on social media. So to be honest, this guide is focused to digital influencers. And I think that we all know at least 20 digital influencers nowadays. And this guide presents 3 scenarios. The first one being advertising by an influencer. So this means that we have a third party's message that stimulates consumption of goods and or services. So we have here 3 key things. The first one being the promotion of a product. So you need to be an influencer and you need to be promoting a product or a service. You also need compensation or some type of commercial relationship with the brand. And the third one, the most important thing, the advertiser needs to have some type of influence on the content of the message. So usually what happens is that the influencer receives what we call a briefing, which is basically a text with instructions, just saying you need to say that, you cannot say that about the product. So it's basically instructions. And also the influencer guide indicates the need for the influencer to identify the content as an advertisement. So for example, if we are talking about Instagram stories, they need to add hashtag ad or hashtag advertisement. And if we're talking about post, for example, the post needs to have that new Instagram tool, which shows that it has a paid partnership. So a second scenario that this guide brings is activated messages, which means that this is a reference by an influencer to a product or a service without any type of control or compensation by the brand. So This is not characterized as an advertisement, but we need, of course, to observe the principle of transparency, especially when we're talking about consumers. So what we recommend usually to influencers is that they at least briefly mention that they have a previous relationship with the advertiser. We also have a third scenario, which is the spontaneous mention by the influencer about the brand or the product. And this is not an advertisement, and it doesn't need to follow the guideline rules. Lastly, we need to consider the increasing relevance of the advertisement made by influencers. So CONAR recommends opening channels of awareness in general and learning about the parameters for a responsible promotion. Now
Roberta,
moving on to my...
One question,
Sure.
Roberta. Is CONAR like in Mexico a non-binding? Are these guidelines non-binding? Are these just informative for the authorities? Because here in Mexico, CONAR is not a binding association. It's just somebody that can assist us so we can educate the authorities regarding different cases. Is it the same in Brazil as well?
Yes, it is the same. CONAR is non-binding, but we always recommend to clients that they follow the rules, especially because they have this really updated rules regarding social media and influencers. And we have a lot of influencers that come to us just asking, oh, can I do that? Can I do this? And it is important. It is a good tool to have, just to keep in mind that you need to follow these basic rules that are not actually binding.
Okay, that's good to know. And obviously, I want to add that if you have any questions, please put it in the chat, and then I can read them, and then we can go, so we can make it a little bit more active. So I'll let you speak, Roberta. Sorry to interrupt.
Sure, no problem. And just moving on to my last topic, which is also a CONAR guide, and which is not binding, but is we recommend it to our clients. And is this guide that CONAR developed with Google and the São Paulo Public Prosecutor Office. So basically, it is a guideline for online. So it is focused on online advertising at children's audience. So it basically states that advertising should consider minors as people in development, and it needs to undertake actions to preserve their image and identity. And it also considers the impact of communication on ethical and social values. Okay, so what's the meaning of that? It means that advertisements should not encourage dangerous behaviors, and it should avoid topics that are considered inappropriate. So let's say tobacco, firearms, or alcoholic beverage. And it also requires a special care as to the child actually that child's ability to actually understand the statement. So for us as adults, it's really easy to see when a propaganda is exaggerated or misleading, but we are talking again about people in development. So you cannot say things like, go to the store and buy this doll, buy this product. You cannot use this type of imperative speech. So this would be forbidden according to CONAR. Also, of course, we need the supervision of parents and legal guardians when it comes especially to child's online activities and personal data of minors. So this is an important topic because we have a special law for that, which is somehow new in Brazil, which is the Brazilian General Data Protection Law. And it has a special attention to minors' data. And when I say minors here, I'm talking about children under 12 years old. So it is very specific. And in this type of case, when you're dealing with children's data, the children cannot be asked, you cannot ask or induce the share of their data. So if you want to process personal data of kids, you need to first obtain prior consent with their parents, at least one of their parents or legal guardian. And lastly, I just want to say that the advertiser and the influencers, they of course need to comply with other Brazilian rules and legislation. So when it comes to kids, we have two main legislations, which are the Brazilian Statute of the Child and Adolescent, and also the Brazilian Consumer Defense Code. And of course, you also need to comply, at least that's what we recommend, comply with other CONAR codes and guidelines. So I think that's all. I just want to say thank you. And if you have any comments or question, feel free to reach me.
Thank you very much, Roberta. Thank you very much. I think if we have more questions, we will leave them at the end, but I think there's a lot and more in a jurisdiction just like Brazil. Ariela, thank you very much for being with us. Please let us know what's happening in Chile.
Thank you, Jose. Well, I'm very happy to be here. Thank you for inviting me to talk. And I'm going to be speaking about some developments of the last year or last year and a half in Chile. And of course, they are very influenced by the pandemic. So this is why what you're going to see here are mostly things related to e-commerce, because as happened in the whole world, we have had an explosion on e-commerce, and everything moved to that, right? To sales online. And because of that, the digital economy is the one that has been more developed in the last years, especially regarding advertising, which is what we are talking now. And the first thing that happened is that CERNAC, which is our consumer products and consumer service of the government, has made a wide, also it's more a report about dark patterns and how they see it and how they foresee that it's going to be regulated in the future, and probably what will happen with them, and what is the view of the CERNAC about that. We also have that's soft law, and how you were talking, like happens with CONAR. The CERNAC report, it's only a wide or a report with some lines that we can understand. But then we have a real new regulation about e-commerce that we will be talking about. And finally, I will be talking about other things that have happened related to alcoholic beverages and some taxes issues. So first, as I said, the CERNAC, which is our consumer service, did a report regarding dark patterns and how they see them. And if you don't know, dark patterns are those things that are hidden in some way online when you are looking at a website, and then you are kind of forced to do, or you are manipulated to move to here or there or wherever without really knowing exactly what you are doing. And for example, here it's like, are you sure you want to cancel your membership? And they give you a big no, and twice no, and then the yes. So it makes an influence in your decisions. And this report is from May this year, and it's focused, of course, in e-commerce practices, and included 100 companies that participate in the Cyber Monday of last year, the 2020. And the objective, how it says here, was to know a little bit more what is a dark pattern and which are used here in Chile, and give a guide to the consumers about it. Here is a definition about it, and says that it's strategies conceived to exploit behavioral biases in order to buy or do something. So it's what I was explaining, and the most common strategies that were found in the report were signs of urgency or scarcity, like only 20 hours to buy, or there are only 3 more items available, or things like that. or what is called roach model that gives you, it's very easy to get into something, but it's very hard to get out of a contract or things like that. The testimonials that are not really clear where they come from or how they were classified, or drip pricing or hidden costs. We're gonna see some cases, disguised advertising, diverting attention. You are in something, and then something pops up, and you get your attention on that, and then your decision is moved by what is happening in the website. Also, confirmed shaming, which is where they make you to feel shame about what you are doing. It's like you really don't want an offer, or really don't want 40% off or things like that. So they force you to act in some way. So those are what the black patterns that they found, and here are some examples. Here we have the one that is very, very common. We all have seen that, which is that you have to register or give me your information in order to continue in the website. Or here you have many testimonials, but they're all like full evaluation. It's 5 points to all of them. It's kind of weird, right? They didn't say how many were exactly there, and so it's not clear. Or here you have the only for 24 hours, right? Here you have a counting, countdown, and things like that. So about all of this, there is one case that they mention in the report as something that in the future will be seen as a black pattern, of course, and could be sanctioned, which is a hidden cost. It happened with airfares. For example, when it doesn't say that it doesn't include the bag, or doesn't include the seat and the number where you are sitting, or things like that. So this happened in 2019, and it was sanctioned as misleading advertising, which has a very high fine. So what we can see of that, and before going to the regulation, I mean, what we can see from this report is that the CERNAC is really seeing black patterns as something that will be sanctioned in the future, that is not, I mean, good for them. They don't see it as a transparent advertising. So we have to be kind of aware of that and try to be careful with the use of them. Then, as I said, we have a new regulation in e-commerce, which will be enforced in March 2022, and it was published now in September. And it covers many things, but because I don't have too much time, I just wanted to focus on some advertising related issues. Especially, well, he talks about the consent in e-commerce. What is very interesting is that it really makes the difference between the platform operator and the seller, and when the seller and the platform operator are the same one, or when it's a third party, and who has the obligation really about the information, the transparency, and it's going to be the platform operator. But if you are the seller and you are using a platform that's not yours, you are anyway obliged to give all the information to the operator, so the platform can inform to the consumer. That's in general what it says, but it's very interesting about how it regulates in each of the situation that could happen. What is the responsibility of the platform operator, and what is the responsibility or liability of the seller? There are also those obligations regarding terms and conditions, but what is very important here is that the penalties are very high, and it includes the advertising as part of the contract of the sale. Wherever you promote or you add, I mean, in your website, in your platform, it's going to be part of the contract, and it's going to be something that is binding for the one that is offering it. It's very complicated because in some way it gets into the systems, and it is regulated that how it says here that the objective conditions of the information contained in the platform through which the product is acquired or the service is contracted that constitutes advertising under the terms of the fourth paragraph what shall be understood to be incorporated into the consumer agreement. So what is complicated here is that when you are in a platform like eBay, for example, and something is promoted there, then there will be an obligation regarding what you promote or what you are advertising. And then we have to see if the platform only gives advertising, like for example, Google maybe, or it also sells, because if you have a way to sell in, then the advertising will be part of the contract. It's gonna have some problems in the application. We're gonna see what happens. It starts, as I said, to be enforced next year. So I wanted just to warn about this new regulation. And then something that is more, not that digital, in alcoholic beverages, we had, of course, like everybody, many regulations regarding the advertising of alcoholic beverages, but now we have new ones from this year, but the specific regulation will be clearer probably next year. It's not ready yet, but what it says is that it's not possible to give alcoholic advertising in any kind of sport, except for those that international and like really big or massive, what is not defined. So it's going to be a problem to know what exactly it is. And also it gives some new labeling regulation in the packaging of the alcoholic beverage with some warnings, and these warnings are those that has to be really in the new regulation, that it's not exactly ready and will be ready, but the law is ready, and this is going to be a fact. We have also many new restrictions regarding the hours of that you can put advertising in TV and in radio, and what kind of advertising. So it's going to be something to be careful about. We will not be able to use the brand of a alcoholic beverage anymore in any kind of sport uniforms or shirts. What maybe in other countries is something very normal, but here it was, I mean, until the last year, you could put those kind of brands and not really in advertising, but you could put and use that it will not be allowed anymore. And then we have some taxes new developments from the, I mean, for the digital services, any kind of services that are provided from a foreign country will be are already charged, but by the VAT, 19%, and that includes even the advertising services. So it's something that all of those that work in this area has to be aware of. As I said, includes all kinds of services that are provided in a digital way, and especially advertising, regardless of the mechanism through which it is delivered or created. So we're going to be charged of that, and it's going to be something. It is being something now that the authority is very concerned about. And then finally, about influencers, that Roberta was talking about influencers in general in Brazil. Well, here is also a big thing, the influencers. And what happened is that the last year, the taxes authority was very concerned about what is happening with them, because of course they were the way of promoting everything here in Chile and everywhere, I know. So there were questions about their services and if they are charged with VAT, and the decision was that they are not, but they, as we see, but they are charged in what they earn in the income tax. So this is what has been resolved about that, and that's, I think, something that was expected. So it's fine that happened. What was good is that the VAT at the end of the day is not applying to this guy. And that is what I wanted to talk to you about today, last developments, and I'm open to whatever you have in questions. Thank you.
Thank you very much. Thank you very much, Ariela. Regarding the influencers and the taxability in Mexico, they're trying to pass a bill regarding the same. I don't know if it is going to go through, but I think it's something that's happening in Latin America, and well, it's a reality. Kelly, yeah. Thank you very much for joining us. It's a pleasure to see you, like always. And please let us know what's happening in Canada regarding advertising matters.
Wonderful. Well, thanks so much for all of those in the audience for joining us today, and thanks to Gala and Jose for organizing this year in review. I'm very glad to be presenting with such an esteemed panel today, and we'll be giving you some updates from Canada. So overall, I'm going to start with a couple of key federal deceptive marketing practices enforcement actions from 2021. Then I'll address a self-regulatory update in food and beverage advertising to children. Next, I'll highlight a couple of interesting consumer class actions. I'll turn to address some COVID enforcement because we can't seem to get away from that. And then I'm going to end with a quick overview of some very extensive Canadian privacy law changes. With that, we'll start with the federal regulatory enforcement actions. So just to set the table, the key federal governmental regulator of misleading advertising in Canada is the Competition Bureau, and I've put our Commissioner of Competition there on the slide. It is an independent law enforcement agency, and it regulates various economic disruptions in the market. Its key legislation is the Competition Act, which governs antitrust provisions, mergers, criminal conspiracies, and as well as what we're all here for, which is the deceptive marketing practices section. There are both criminal and civil options for enforcement federally in Canada. And when we talk about what enforcement looks like, the corporate civil sanction is an administrative monetary penalty up to $10 million, which goes up to $15 million on a corporation's second order. There's other possible penalties, including paying restitution to affected consumers, posting corrective notices, making orders to comply with the law. And the standard term is 10 years for what they call a consent agreement. So the Bureau typically attempts to enter into a consent agreement with the investigated organization. It's less common to litigate these matters in Canada. And typically they request 10 years of compliance, during which the Bureau can make information requests to audit for compliance. And 2021 was a fairly light year on deceptive marketing practices and actions, but there was significant new funding given to the Bureau this year. So I think that we can look on the horizon to a more active period of enforcement. So I'm going to cover a couple of cases from last year, or from this year, I should say. The first one is a case involving Flight Hub, which is a website, a travel website that facilitates the purchase of travel services for consumers. And the Bureau alleged that Flight Hub made misleading claims, including those that were about the price of flights and related costs and terms of those flights. And including claims about the company's cancellation policies, policies for rebooking, and getting available refunds and credits, seat selection. So kind of a wide host of claims. And also at issue were misleading testimonials, with the Bureau alleging that Flight Hub posted online reviews of its services, but these reviews were actually posted by the company and not from customers, as was represented in the claims. So Flight Hub, in its consent agreement with the Bureau, settled the matter and agreed to pay $5 million And interestingly, two of the directors each agreed to pay $400,000 Canadian each. And I think what we can take away from this action is that the Bureau is still very much focused on enforcing in the digital economy, particularly since most transactions these days are occurring online. And in particular, they continue to be focused on pricing claims and the issues of misleading reviews. In this case, the faked testimonials, allegedly. It also reflects the Bureau's focus on consumer harm that's associated with COVID, given that it is the travel industry. And I'm going to talk about that as a separate topic a bit later on. For those from Canada in the audience today, another more minor interesting point here is that the Bureau first entered into a temporary consent agreement with Flight Hub in 2019, which had prohibited Flight Hub from making these kinds of false or misleading marketing claims while the Bureau conducted its investigation. So we may be seeing those kinds of interim measures in the future. All right, the other Bureau case, the federal governmental enforcement action, was with Revive-You Media, which operated a website promoting health and dietary supplements. And this website represented that consumers were able to order free trials without any obligation. So some of the claims at issue were, risk-free trial, just pay a small shipping fee, where in practice, consumers were actually signed up for a monthly subscription for these products. So, around $100 Canadian in monthly fees. And interestingly, this one was litigated, which is not typically what happens. As I mentioned, the Bureau seeks to go into consent agreements for most of its enforcement actions. And the court ordered Revive-You Media to pay a $15 million fine and also issued a 10-year court order prohibiting any of those kinds of deceptive trial offers. So I think this topic would be of interest to those with businesses that have ongoing subscription payment terms, as consumer protection laws in Canada while they are provincially regulated, most of them are very strict, particularly when compared to other jurisdictions, and are increasingly an area that has been picked up by Class Action Council in Canada, as the requirements for entering into a valid subscription agreement with consumers are fairly strict, and we've seen some fairly high-level subscription companies, being the target of class actions, including for related promotions like free trials. Okay, so the next topic I wanted to address was some updates in self-regulatory sphere in the food and beverage sector. So over the summer, a number of food self-regulatory organizations got together and issued a new code and guide for the responsible advertising of food and beverage products to children. And Ad Standards, which is the Canadian National Advertising Self-Regulator, is going to be responsible for administering this code. So those who work in the space may be aware that previously pre-clearance was only required for broadcast advertising. And now advertising for food or beverage in any media is not going to be permitted to be primarily directed to people who are under 13 years of age, unless the product satisfies some standards for being healthy. So what is healthy is fairly up for debate, and it will depend on the type of food. For example, prepackaged foods have a set standard of limitations on items like saturated fat, sodium, and sugar. So it will be very specific as to what is excluded from this self-regulatory requirement. But if a product doesn't meet its healthy standard, then advertisers will need to determine whether the advertising is primarily directed to children. And some of the criteria that are at play here include the nature and intended purpose of the food, the manner that the advertisement is presented, and when and where the ad is placed. And some of you may recognize these criteria as are very similar to those that are applied in the context of Quebec and its general prohibition against advertising to children, which is applicable to any food product or any product category, not just food and beverage products. There are some exclusions to this new self-regulatory code and guide. For example, on packaging, on-premise advertising, charitable type ads. But there's also some other aspects of the new code which are fairly prescriptive, including a restriction on imperative language, even in the case of excluded categories. So something to watch out for in this area. Okay, so the next category I was going to give a quick update on is the class actions. And there's a couple that I wanted to touch on. We're seeing more and more of these actions, and I think it's an area of increasing risk to watch out for in Canada. And we're seeing kind of expanded types of claims into interesting causes of action. This one is Bergen and WestJet Airlines, which is a national airline in Canada. And that issue here was the airline's rate tariff, which is a legally required disclosure document with various fees. And the rate tariff included conflicting claims as to whether or not a fee was going to be charged for a passenger's first checked piece of luggage. In some cases, it stated that the bag was free if it was the first, and then other cases, it stated that there would be charges, and then passengers were indeed charged for their first bag. Amongst a number of different causes of action, in tort, breach of contract, was under the Competition Act, which has a double ticketing offense, which, in order to have a private right of action, needs to meet the criminal standard for double ticketing, and that's where you have two listed prices for the same item, and then you charge the higher price. So it's an interesting use of kind of a fairly neglected provision under the Competition Act. This class action has been certified, and I think it's interesting to see that the Competition Act and its causes of action are being brought into some of these cases. Another example of this is a case with Airbnb and its double ticketing of both on the map and then later on charging different prices depending on the particular inputs that people give. I'm not going to get into that case, but I did wanted to bring your attention to this other action in Ontario, which settled for 6.95 million Canadian. And in this case, it was about representations used about organic cannabis, medical cannabis in Canada. And it turned out that this medical cannabis producer used unauthorized pest control products, so pesticides, in producing some of its cannabis products, was subject to a recall. But again, we're seeing a lot of the, Consumer Protection, Competition Act, these causes of action being brought in to these kinds of consumer claims. So I'm mindful of time. I'm going to just, can't go by a day without talking about COVID. I'm so sorry. But just a quick note to say that, like many other jurisdictions, Canada, has had quite a number of regulators focused on dealing with the response to COVID-19. We've seen real joint enforcement efforts between the Federal Competition Bureau and our federal health regulator, Health Canada. There's been many compliance warnings issued to businesses across Canada, including some national retailers. The picture that I have here is early on in the pandemic, a large national retailer was selling standard surgical masks by representing that they were N95 masks. So a lot of these types of claims have been addressed. There are literally hundreds of enforcement actions for claims about preventing disease or protecting against a virus, for masks, food, natural products, air filter, air purifiers, herbal remedies, you name it. So again, continues to be an area of extensive enforcement. All right, and my last topic here is just to address what is on the horizon for Canada, which is a huge privacy law update. So as a quick background, we have federal and provincial privacy legislation for private sector in Canada. Currently, Quebec, BC, and Alberta have their own provincial statute. Last year, a huge overhaul to the federal statute, PIPEDA, was introduced and got set aside with the federal election in the fall. So we're waiting for the speech from the throne, which is kind of the start of the new legislative agenda federally on November 22nd, my birthday. So happy birthday to me. Where we're going to see, hopefully, where the federal government is going to be taking these updates for privacy. These are some of the, in the bullet list there, some of the provisions that were in the old bill. Remains to be seen what the federal government does for this new session. But importantly, Quebec did pass its updates to its provincial privacy legislation with many of the same types of provisions. They're being implemented over the next several years, but you're going to see, serious sanctions, increased powers for investigation and enforcement, and a bunch of new rights, kind of similar to EU GDPR style rights. And Ontario doesn't want to be left out. It looks like it's going to be developing its own private sector privacy legislation. There was some consultations last year for what should be in that statute. So stay tuned, big developments in privacy in Canada. So thank you for your attention, and I guess I'll turn it back to Jose unless he's going to.
Thank you very much, Kelly. It's interesting to listen to you, and now that our president is going to speak, because I think countries such as Canada and the United States are much more up to date compared to Chile, Mexico, and Brazil. But
are you going to say
I'm going to say it because we are in diapers. Correct. We are in diapers. I had to say it because Paula told me right now you have to say it, Jose, and I'm going to say it because we are in diapers. Jeff, thank you very much for being here. It's always a pleasure to listen to you. Can you please tell us what's happening in the United States?
Yeah, no problem. In 10 minutes, I'm going to give you the big summary of everything that's going on in the U.S. Anyway, thanks, Kelly. That was interesting, and everyone else as well. Hi, everyone.
Thanks, Kelly.
I'm going to do 10 minutes and some things that are, I guess, on my mind about what's going on in the United States, in particular, focused on the FTC. I think the first thing is it's really hard to talk about FTC enforcement right now without recognizing that we're in this period of immense change at the FTC. I think we all expected when we saw the transition from the Obama administration to the Trump administration that we would see a real big difference in terms of enforcement at the FTC. But that's not really what happened. There was this really remarkable continuity, in fact, related to enforcement priorities and the way in which FTC was approaching problems. And it really was, what was really going on was the staff just kept doing what they were doing all along. And you didn't see a big shift in policy. And now that Lina Khan became the new FTC chair this summer, we really have started to see some changes. And I think she's looking at the FTC with certainly not only a fresh pair of eyes, but really thinking about it in a complete way. So I think that sort of the old lessons and the old approaches and sort of all the things that we've come to expect about the things we need to worry about, the FTC worrying about in the U.S., I think those things are going to change, at least to some degree. The truth is she hasn't been chair that long. FTC is still finishing up old cases that were authorized, before she became chair. So I think we're going to continue to see some stuff that there is that has been going on for longer. But I think what we're already starting to see is really strong indications that the FTC is going to be approaching things very, very differently. So I think we all have to be prepared for that. The other thing that I think is important to understand is that, over the last several years at the FTC, there's been this very, very public debate going on among commissioners about whether the FTC's advertising enforcement program is working. Some of the commissioners, the Democratic commissioners primarily, have really been talking about the fact that, most FTC orders don't involve payment of penalties, don't involve admissions of liability. They don't have a lot of teeth to them other than companies agreeing not to violate the law again. The commissioners, the Democratic commissioners, particularly, Commissioner Slaughter and Chopra, really had been pushing this idea that the FTC has to be more aggressive and has to start getting penalties and has to start really penalizing people and creating settlements that have a deterrent effect. So I think that now that Democrats and new Chair Khan is taking control of the FTC, there's this sort of strong support movement to start making the FTC get more aggressive when advertisers cross the line. The thing that happened is this sort of as the FTC got this power, or as there was consensus that this is the approach they wanted to take, the other thing happened, which is the Supreme Court took away some of the FTC's enforcement authority, and basically is making it much more difficult for the FTC to get financial relief. The result of that is not only is the FTC going to Congress trying to get that authority back, and chances are it will get all or some of it back at some point, but that the FTC is really being forced to be creative about the ways in which it goes after companies. And I could do a whole hour just on that issue, but what that means is that the ways in which the FTC is going to exercise its muscle, show its muscle, those ways are going to feel very different and look very different than they did in the past. So let me give you a couple of examples of some of the topics that the FTC is focused on. First is endorsements. As I'm sure many of you know, the FTC thinks about the endorsements from the perspective of its sort of own advisory guidance about endorsements. I'm not really going to talk about that here. What I am going to talk about, though, is the fact that the FTC just sent out something called a notice of penalty offenses. And chances are there's virtually no one on this call that has ever heard of notices of penalty offenses or really knows what the FTC is talking about. And that's because it's this long dormant authority at the FTC, where basically what it means is that if the FTC litigates a very particular issue and then provides notice to somebody else that, hey, if you engage in those particular acts and practices, you're violating the law. And because they've gotten that specific notice about that specific litigated issue, the FTC has the ability to get civil penalties if that person then violates the law. The issue is that under Section 5, which is the FTC Act, which prohibits unfair or deceptive acts or practices, FTC really only has the ability to get injunctive relief, which at this moment, for the most part, means they can tell you to stop, but there's not much else that they can do. It used to be that they were getting certain kinds of restitution and disgorgement, but that, for the most part, has now stopped. So what the FTC is looking at, the FTC doesn't have the authority, however, to get civil penalties. So what the FTC is doing is looking for ways to get civil penalties or other financial relief from companies now that the Supreme Court has taken that authority away. Well, one of the things that they came up with was issuing these notices of penalty offenses. So about 2 weeks ago, the FTC sent notices of penalty offenses to, essentially they sent 3 waves of notices of penalty offenses. They sent one to for-profit educational institutions. They sent one to, well, not so that many, 20, 30, something like that. They sent one to more than 1,000 companies that are in the sort of business opportunity business. And then they sent more than 700 notices to just big companies and big ad agencies warning them about endorsement practices. And basically what the FTC did here was summarize some basic principles from the FTC endorsement guides, but were principles that they could specifically point to litigated decisions about. And basically said to these companies, if you violate the law now, if you engage in improper endorsement practices, we're going to come after you, and now you're liable for civil penalties. How did they choose the 700 companies? I don't know how they chose them, but what I do know is they didn't choose them based on an investigation that they were engaged in any kind of illegal behavior. They basically went out to 700 of the biggest companies, biggest marketers, ad agencies in America, and basically said, look, we're now creating a situation where you better be nervous because you're on our radar now, you're on our list, and now that you're on our list, if you violate the law, you're going to get treated differently than other companies who we don't have the authority to get civil penalties against. Will this work? Will the FTC be able to get civil penalties against a hand-chosen, hand-selected group of companies who were singled out instead of others around the country for endorsement practices that may not be identical to the ones that were litigated decades ago? No one knows at this point. But it is a big, stern warning from the FTC that they care about endorsement practices and they're planning to engage in significant enforcement in the ways probably stepped up more than what we've seen in the past. One really interesting piece of sort of endorsement guidance that we did get prior to Lydia Khan becoming chair, which is worth keeping in mind because it was sort of raised somewhat in the notice of penalty offenses, was the FTC's closing letter against Yapo. The FTC issues closing letters when they do an investigation, but they decide not to take formal action. Often they do that either because the violation didn't rise to the level of resources that are required to bring the case. Sometimes they do it because it poses a new issue, and instead of penalizing a company right away, they want to give industry a little bit of information or heads up that this is an area that they're concerned about. What the practice that they were concerned about in YAPO was essentially a consumer review moderation tool that allowed companies essentially to hold up or delay or prevent negative reviews from being posted, negative or other types of reviews from being posted on consumer review, on their own consumer review areas of their websites and platforms. FTC basically said use of the tool in that manner is improper. That if you're going to host consumer reviews and tell people that this is the consumer reviews, you better post all the consumer reviews unless you have a really good reason not to. The FTC acknowledged that it's perfectly fine to moderate your reviews to get rid of irrelevant stuff or stuff that would be inappropriate to post because of profanity or something like that, but that you couldn't sort of make these arbitrary judgments that if you've got a consumer, if you sell TVs and people are posting reviews about your TVs, you can't just delete the negative ones. You can't delete the ones about customer service. You can't delete the ones about your return policy. If it relates to the product in some reasonable way, the FTC expects you to post those reviews. So, if you're thinking, in light of this giant announcement from the FTC saying, hey, we want to get civil penalties from companies who are engaging in improper endorsement practices, the two things you want to do here are re-review the endorsement guides, take a look at the notice of penalty offenses, which is posted on the FTC website, and make sure you have a good understanding of the kinds of endorsement stuff your company is doing. And 3, get your consumer reviews in order. We are literally almost out of time, and so I'm going to just spend 1 minute and highlight to you some of the things that were on my mind. One is Made in USA, another hot topic at the FTC. The FTC's Made in USA standard requires products to be virtually all made here. The FTC just issued a new Made in USA rule, which means they're again going to be stepping up enforcement in this area as well. On the disclosure front, the FTC continues in all kinds of different ways to express serious concerns about whether advertisers' disclosures are effective and whether they satisfy the FTC's clear and conspicuous standard. One of the things you see in FTC orders and FTC guidance is they continue to get more and more prescriptive about what they mean by clear and conspicuous. Is it unavoidable? Is it immediately adjacent? Don't assume that your disclosures that are buried somewhere or that a click away are that are going to be effective, or you may end up paying $18 million because your disclosures just weren't up to FTC standards. Another area where the FTC can get civil penalties is by violating the mail order rule. The world is all about e-commerce these days. If you're shipping products to consumers that they bought online in the U.S., you better make sure you understand what the mail order requirements are, which is that you have to have a reasonable basis for your shipping claims, and that you have to ship when promised, and that if you can't ship when promised, you have to take certain procedural steps to make sure that you're doing what you're supposed to be doing, or again, they're going to be looking for civil penalties. COVID, unprecedented level of enforcement of COVID at the FTC. You don't need to hear more about that from me. And finally, there's a lot of other hot topics at the FTC right now. I think that as Chair Khan starts to really get things reorganized, we're going to start to see a lot more digging in by the FTC into some of these and others. Jose.
Much, Jeff. Thank you very much for your complete presentation. And before we leave, we have Monday. We have another event with Ana. Just so you guys know, I wanted to tell you a little bit about something about Mexico. But you will have to come into our event on Monday, so you know a little bit about the new transparency law on advertising. And just so you guys know a little bit, it's something that is affecting agencies, announcers, and media companies, and it's changing the industry in Mexico. So due to time, I'm not going to be able to talk about it, but if you are interested, please join us on Monday in our event. Jeff, Kelly, Ariela, Roberta, Gala, thank you very much for your time. Hope everybody enjoyed. Like I always enjoy being with you guys, and it's always a pleasure to being with you. Thank you, guys.
Thank
Bye.
you.
Thank you, everybody. Thank you.
Bye.
Bye. Bye.
Thanks all. Bye-bye.
You.